Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content. And today will be the day I earn that subscription. For today's case, we are learning through the misfortunes of Boston in the case of Shooterfield versus Boston. Boston, Massachusetts has a city hall, like so many cities do. And outside their city hall, they fly flags. Like so many cities do. They fly the American flag, and they fly the state flag, and they also fly occasionally other flags. What kind of other flags? Well, they fly flags for private parties. Now, the city had a pretty decent explanation for when these occur and when they don't occur, that they're normally reserved in commemoration of some kind of event or some sort of, major goings on. So occasionally, for example, this flag of a different foreign country, because, they're ambassadors in town or some sort of state visit, something like that. Very nice. City flags of other organizations when appropriate for like Arbor Day or something like that. All kinds of things like that, right? Now, up until the Christian flag at issue in Shooterfield, the city of Boston had never, ever denied anyone the ability to fly their private flag for any of these events. Not once. Ever. But the Camp Constitution wanted to fly its flag. So Camp Constitution is a private camp for kids, and they are a religious camp. And among other things, they fly the Christian flag at their camp. So for Constitution Day, which is the day the Constitution was signed, they wanted to fly at the City Hall the flag of Camp Constitution in honor of the Constitution Day, which is also the Christian flag, a religious flag, one might say. Now, the city of Boston said no, not so much. Now, initially, this argument looked really, really interesting to me because, of course, we have religious freedom in the United States. We don't have the ability, everyone is free to have their own religion or none at all. And the state isn't really supposed to get involved with it. So we had the prospect of the Christian flag flying outside at City Hall, which could potentially look like the government speech, because it's City Hall. A passerby might view the flag along with the American flag and the state flag and see the Christian flag and say to themselves, the city seems to be endorsing Christianity, which, they're not really supposed to do. This was the argument from the city of Boston to start with. And this argument had some merit to it. We have potentially an issue with endorsement. We can't treat religion any worse than a secular counterpart. But then again, this is a specifically Christian flag, and it could be misconstrued as the government speech. So initially, I came into this case with, this very a nuanced idea about what this argument could be. This very sort of, balancing of all these sort of competing interests and stuff, this really, really sort of complicated, nuanced, interwoven analysis. And then the city of Boston decided to just shit all over their own case. Shit in the bed, as we have now decided the phrase is, via Amber Heard. Because they said at oral argument, because they were asked twice, they said they would have flown the exact same flag from Camp Constitution if they had called it something else. You see, the problem was on the application form where they asked permission to fly the flag. On the application form, they called it the Christian flag. That was the problem, what they called it on the form. If they had called it literally anything else, like they could call it the Camp Constitution flag, that would be fine. We just had a problem that on the form you called it the Christian flag. Why didn't you call it the Camp Constitution flag? Do you see the problem? Do you see the problem? Because how would anybody know that? How would anyone know what was on the form? The passerby going by Boston City Hall would see an American flag, would see a state flag, and see a flag that looks suspiciously like the Christian flag. But apparently it's not the Christian flag, it's the Camp Constitution flag. And this random passerby is somehow supposed to know this, and that would have made the difference. The exact same flag. Literally the exact same flag. Again, they asked the question twice, just in case there was some confusion. No, there was no confusion. We would have flown the exact same, literally exact same flag had you called it something else. So we took this incredibly nuanced, difficult argument, and it became real simple, real fast. Because the only reason we were discriminating against it now was religion. Religious animus. It wasn't because we were worried about someone seeing the flag in endorsement. We weren't worried about the endorsement possibility because the same stranger on the street would see the exact same flag. So endorsement isn't our issue. No, we just don't like it what you called it on the form. Straight religious animus. So, argument is over now. The argument is just done. Thanks for playing along, Boston City at home. Thanks for playing along, but you're just done now. It's over. You've lost. So, unsurprisingly, the Supreme Court ruled against Boston 9-0 because, they killed their argument. They just went before the U.S. Supreme Court, put a firearm to their skull, and pulled the trigger. Yeah. So, yeah. So we're going to review this case and what it has to say about religious freedom in the United States. So, let's get started with this. All right, so this is written by Justice Breyer, one of the more left-leaning members of the court, which, unanimous opinion, why not? When the government encourages diverse expressions, say by creating a forum for debate, there was a whole argument there about whether or not it was a forum or not, but it doesn't really matter anymore. The First Amendment prevents it from discriminating against speakers based on their viewpoint. But when the government speaks for itself, the First Amendment does not demand airtime for all views. After all, the government must be able to promote a program or espouse a policy in order to function. Yeah. The line between forum for private expression and the government's own speech is important, but not always clear. This case concerns a flagpole outside Boston City Hall. For years, Boston has allowed private groups to request use of the flagpole to request flags of their choosing. As part of this program, Boston has approved hundreds of requests and raised dozens of flags. The city did not deny a single request, not one, until 2017, when the director of Camp Constitution asked to fly a flag that looked suspiciously like the Christian flag and also called the Christian flag because apparently that matters. Boston refused. At the time, Boston admits it had no written policy limiting the use of flagpole based on the content of the flag. The parties dispute whether, based on these facts, Boston reserved the pole to fly flags that communicate governmental messages or instead open the flagpole for citizens to express their own views. If the former, Boston is free to choose the flags it flies without constraints of the First Amendment. If the latter, not so much. We conclude that on balance, Boston did not make the raising and flying of private groups' flags a form of governmental speech. That means, in turn, Boston's refusal to let the flag fly based on its religious viewpoint abridge the freedom of speech. Yeah, it's like, yeah. There were so many weaknesses in this case. There were many, many weaknesses. The we didn't do it because they called it that was obviously the most frustrating weakness. But, it's not the only weakness. So, yeah, sure. Also, it is also not governmental speech. That is that definitely makes sense as well. Yeah. The flagpole at issue stands at the entrance of the Boston City Hall, which might imply governmental speech, but, the conduct of the government can belie that initial impression. Built in the late 1960s, Boston City Hall is a raw concrete structure, an example of brutalism structure. Critics of the day herald it as a public building that articulates its functions with strength, dignity, grace, and even glamour. The brutalism thing didn't last very long, but whatever. And the design, as they note, has proved to be more controversial in later years. Brutalism didn't really stick on as an architectural movement. More to the point, Boston City Hall sits on City Hall Plaza, a 7-acre expanse paved with New England brick, inspired by open public spaces. Like the Piazza del Campo at Siena, the plaza was designed to be Boston's fairground, a public gathering space for the people. On its plaza, near the City Hall entrance, stands 3 83-foot tall flagposts. Boston flies the American flag for the first pole, along with a banner honoring prisoners of war and soldiers missing in action. From the second, it flies the flag of the Commonwealth of Massachusetts. And from the third, it usually, but not always, flies Boston's flag, a sketch of the city on the hill, encircled by a ring against a blue backdrop. How nice. So we got the country flag, we got the state flag, and sometimes, but not always, the city flag. Okay, Boston makes the City Hall Plaza available to the public. Boston acknowledges that this means the plaza is a public forum. The city's policy, where possible, to accommodate all applicants seeking to take advantage of the City of Boston public forum, including the plaza and the area at the flagpole's base. Yeah, when you have a public forum, the government's restrictions on freedom of speech go way down. The quintessential public forum is the city park, right? You can say anything you want, within the lines of the First Amendment, of course. You may not be able to use any equipment you want, because then you're into some sort of time, place, manner restriction, specifically manner. So if you want to use some sort of amplifying device, they might have an issue. But otherwise, you're free to get on the milk crate and speak to whoever happens to be walking by. That is one of the freedoms of speech. Okay. So apparently they created a public forum, which, means they have to allow kind of all the speech. So there's that too. For years, since at least 2005, the city has allowed groups to hold flag-raising ceremonies on the plaza. Participants may hoist the flag of their choice on the third flagpole and fly it for the duration of the event in typically a couple of hours. Most ceremonies have involved the flags of other countries, from Albania to Venezuela, marking national holidays of Bostonians' many countries of origins, and as I noted, for official state visits as well. But several flag raisings have been associated with other groups or causes, such as Pride Week, emergency medical service workers, and a community bank. The community bank was my personal favorite. The community bank is to fly a flag for the bank at the plaza. I mean, that's my personal favorite. All told, between 2005 and 2017, Boston approved 50 unique flags raised at 284 ceremonies. Boston has no record of refusing a request. We now turn to the events of this case. Yeah. In July 2017, Harold, the director of the organization called Camp Constitution, asked to hold a flag-raising ceremony that September on City Hall Plaza. The event would commemorate the civic and social contributions of the Christian community and feature remarks by local clergy. As part of the ceremony, the organization wished to raise what is described as the Christian flag. They described it that way. To the event application, Scherferfield attached a photo of the flag, a red cross on a blue field against a white background. So the traditional Christian flag is an all-white flag. In the top left corner, there's like a blue square. It's not very big relative to the whole flag, so it's not like an entire quarter of the flag. It's relatively small, roughly the size of the blue field, for example. So imagine an American flag with its little blue portion, and you got about the same size, right? So it's a white flag with that little blue portion, and in the blue portion is a red cross. That's what the Christian flag looks like. Not sure who designed it, but that's what it looks like. The commissioner said no. The problem was not the content of the flag, but the fact it was the Christian flag, or was called the Christian flag. And this is the part where I get out of the room and scream into a pillow, because how stupid do you have to be? How stupid do you have to be? It's not because of the content of the flag. It's not because we were worried that flying the flag, people would see it, the content of it, and associate us with the Christian religion. And that would be bad, because the city isn't supposed to have a religion. No, no, no. It's not because of the content of the flag. It's because you called it the Christian flag. The commissioner is an idiot. The commissioner sank their case before it ever started. The commissioner worried flying a flag at religious flag at City Hall could violate the Establishment Clause. Well, it would be the exact same flag, so I'm not sure how. He told Camp Constitution it could proceed with the event if they would raise a different flag, or critically, as conceded in oral argument twice, if they had merely called it something else. Needless to say, they didn't want to do so. The Camp Constitution sues Boston and commissioners. Petitioners claim that Boston's refusal to let them fly their flag violated, among other things, the Free Speech Clause. They asked for an order requiring Boston to allow the flag, but the district court denies the request. The parties engaged in discovery. The parties agreed to all the relevant facts and submit a joint statement settling them out. So we don't need a trial. We all agree to the facts, including just change the name though, yo. On that record, the district court held that flying the private flag from City Hall would amount to governmental speech. Hence, the city acted within its constitutional authority. The district court therefore grants summary judgment. The First Circuit affirmed. So both the district court and the First Circuit are also idiots. That's more of what we're learning here. Because 9-0. Because this doesn't make any sense. Camp Constitution next petitioned the court for certiorari. We agreed to decide whether flags Boston allows groups to fly express governmental speech, and whether Boston could, consistent with it, deny the flag raising request. Well, you know, so many grounds here. We could go with the fact that, you know, it's just the name though, or we could go with the fact that it's a public forum, or we could go with, you know, it's arbitrary and capricious, or so many other reasons, you know. Just pick one out of a hat at this point. What's your favorite reason to say that this is illegal? Just pick one of so many reasons. Equal protection, free speech, freedom of religion, religious animus, public forum. Take your pick. What do you like? What do you like? What's your favorite? The first and basic question we must answer is whether Boston's flag-raising program constitutes governmental speech. If so, Boston may refuse to raise flags based on Viewpoint. The First Amendment's free speech clause does not prevent the government from declining to express a view. When the government wishes to state an opinion, to speak for the community, to formulate policies, or implement programs, it naturally chooses what to say and what not to say. That must be true for the government to work. Boston could not easily congratulate the Red Sox on a victory, were the city powerless to congratulate the Red Sox on a victory. Were the city powerless to decline to simultaneously transmit the views of disappointed Yankee fans. The Constitution, therefore, relies first and foremost on the ballot box, not rules against viewpoint discrimination, to check whether the government speaks. The boundary between governmental speech and private expression can blur where, as here, a government invites the public to participate. That too, in these situations when the government public engagement transmits the government's own message, and one does it instead create a forum for the expression of private speaker views. In answering these questions, we conduct a holistic inquiry designed to determine whether the government intends to speak for itself or regulate private expression. Our review is not mechanical. It is driven by cases context rather than rote application of rigid factors. Our past cases have looked at several types of evidence to guide the analysis, including the history of the issue, the public's likely perception as to who's speaking, and the extent to which the government has actively shaped or controlled the expression, and perhaps as an unspoken fourth element, whether the government is an absolute idiot. Because that's what does it for me. Considering these indicia, we held the messages of permanent monuments in a public park constitute government speech, even where the monuments are privately funded and donated. In a different case, we've expressed that license plate designs proposed by private groups also amount to governmental speech because, among other reasons, the state issues the plates, maintain direct control over the messages conveyed by actively reviewing designs and rejecting dozens of proposals. A controversial decision, incidentally, from my point of view, but that is what the Supreme Court decided. Though the Patent and Trademark Office has to approve each proposed mark, it did not exercise sufficient control over the nature and content of those marks to convey governmental message. That's the Tam case. These precedents point our way. Applying government speech analysis to this record, we find that some evidence favors Boston and other evidence favors Camp Constitution. To begin, we look at the history of the flag flying, particularly at the seat of government. Were we to consider only the general history, we would find it supports Boston. Flags are almost as old as human civilization. Indeed, flags symbolize civilization. From primordial rags dipped in blood of a conquered enemy and lifted on high on a stick, to feudal banners bearing a lord's coat of arms, to standards of the Aztecs, nearly every society has taken a piece of cloth and endowed it, through circumstances of its display, with a condensed power to speak for the community. That's a very nice way of putting it, very poetic. Little wonder then the Continental Congress, seeking to define a new nation, resolved on June the 14th, 1777, the flags of the United States be 13 stripes, alternating red and white, the Union, that would be the blue part, be 13 stars, white in a blue field, representing a new constellation. Today, the American flag symbolizes our nation, a constellation of 50 stars standing in for the 50 states. And still 13 stripes, although, of course, as a little bit of history, flag history for those of you who like such things, the U.S. flag didn't always have 13 stripes. It's true. While the original American flag had 13 stripes, and it has 13 stripes today, states 14 and 15 did get their own stripe. It's true. And, interestingly, the flag the Star-Spangled Banner was written about was the 15-star flag, because that would be the flag that was flying when Francis Scott Key wrote the Star-Spangled Banner, the 15-stripe flag. Then around state 16, Congress decided this was a stupid plan because, there'd be a lot of stripes. So it went back to 13 and just continue adding stars. This little history tidbit is offered to you by Uncivil Law. Other contemporary flags, both state and local, reflect their communities. Boston flag, for instance, bears the seal and motto rendered in blue and buff, the colors of Continental Army's Revolutionary War uniforms. Not only just the contents of the flag, but its presence and position, have long conveyed important messages about government. The early morning sight of the stars and stripes above Fort McHenry told Francis Scott Key, when he was looking at the 15-stripe flag, and through his poem told the rest of us, the great experiment, the land of the free, had survived the British attack on Baltimore Harbor. No less familiar, a flag at half-staff tells us the government is paying respects to the memory of someone who's died. And the presence of the Royal Standard flying from Windsor Castle Round Tower says the Queen is at home. That's true. The flying of a flag other than the government's own can also convey governmental messages. A foreign flag outside the Blair House, across the street from the White House, signals that a foreign leader is visiting and residence has become a de facto diplomatic mission of the guest home. Yeah, the Blair home, incidentally, I've been to many times because it's also, incidentally, the location of the Federal Court of Federal Appeals in D.C. So I've been in the Blair House many, many times as a result of that. And it's a really cool place, just incidentally. It is very often used by the incoming president as a residence in DC before he's sworn into office. And as they note here, it's often used by diplomats of the head of state when they're visiting. So, a little bit of tradition there. And also happens to be the location of the Court of Appeals for the Federal Circuit. So, a little patent law, a little history, more fun. Let's continue on. The flying, And according to international custom, when flags of two or more nations are displayed together, they cannot be flown one nation above the other in a time of peace. Yeah, so this is part of the reason why, like at the UN, everyone gets their own flagpole, because you can't have a flag above another flag because it implies superiority. And we don't really like that very much. Keeping with this tradition, flags on Boston City Hall Plaza usually convey the city's message. On a typical day, the American flag, the Massachusetts flag, and City of Boston flag wave from the three flagpoles. When flying at half-staff, it communicates a community message of sympathy or somber remembrance. When displayed at other buildings, it marks a mayor's presence. Okay. The city also sometimes conveys a message by replacing one flag with another. When the Boston mayor lost a bet with Montreal about whose hockey team would win, Boston, duty-bound in defeat, hoisted Canadians' banner. Cute. While this history favors Boston, it is our only starting point. The question remains whether, on the 20 or so times a year when Boston allowed private groups to raise their own flags, those flags too express the city's message. So we must examine the details of the flag flying program. I mean, I guess if we want to help Boston save some face, I guess we can get into the minutia of whether this is governmental speech or not. But, okay, let's help them save some face by making them not look like complete morons. Next, then, we must consider whether the public would tend to view the speech at issue as the government's. In this case, the circumstantial evidence does not tip the scale. On an ordinary day, a passerby on Cambridge streets sees three governmental flags representing the nation, state, and city. Those flags wave in unison, side by side, from matching flagpoles just outside the entrance to Boston's seat of government. Like the monuments in the public park, the flags play an important role in defining the identity the city projects to its own residents and the outside world. So, like license plates, the public seems likely to see flags as conveying some message on the government's behalf. Yeah, and then Boston just screws it up royally. Just royally. But as we said, Boston allows his flag to be lowered and other flags to be raised with some regularity. Those other flags were raised in connection with ceremonies at the flagpole's base and remained aloft during the events. Petitioners say a pedestrian glimpsing a flag other than Boston's on the third flagpole might simply look down onto the plaza, see a group of private citizens conducting a ceremony without the city's presence, and associate the new flags with them, not Boston. Thus, even if the public would ordinarily associate a flag's message with Boston, that is not necessarily true for the flags here. Again, this evidence of the public perception does not resolve whether Boston conveyed a city message with those flags. Finally, we look to the extent at which Boston actively controls these flag raisings and shapes the message the flags sent. So Boston may be able to fix all this, by the way. Boston may be able to fix all this, by the way, by some changes to its regulations. Perhaps they'll be less stupid the second time. But, Finally, we look to the extent in which they actively control the flag raisings and shape the message. The answer, it seems, is not at all. That's a problem. And that is the most salient feature of this case. Well, I don't know if it's the most salient feature, Justice Breyer. I would respectfully disagree. It's the most salient feature. I can think of other salient features that come to mind, but sure, let's help Boston save some face and say it's the most salient feature. Okay. To be sure, Boston maintained control over an event's date and time to avoid conflicts, and maintained control over the plaza's physical premises, presumably to avoid chaos, and were provided a hand crank so groups could rig and raise their chosen flags. But it's Boston controls over the flag content and meaning that's a key here, which they didn't care about the content of the flag. They said that. They said that. See, if it had been the content of the flag, the Christian flag, then we would have an entirely different argument. But Boston said they didn't care about the content of the flag. They said that. On issue, Boston's record is thin. Boston says that for all of the 50 unique flags it approved reflect particularly city-approved views or values. Flying flags associated with other countries celebrated Bostonians' many different national origins. Flying other flags, Boston adds, were not wholly unconnected from diversity message or some other day or cause the city or Commonwealth had already endorsed. That may well be true of the Pride flag, raised annually to commemorate Boston Pride Week, but it's more difficult to discern a connection to the city, as to say the Metro Credit Union flag raising a ceremony by a local bank. I told you the bank one was my favorite. Because, like, really? We're saying raising the credit union flag is governmental speech? Seriously? This is what we're going with? What? Was the ambassador from the credit union visiting that day? In any event, we do not settle this dispute by counting noses, or rather counting flags. This is so for several reasons. For one thing, Boston told the public it sought to accommodate all applicants who wish to hold events at the public forums. More stupidity. Accommodate all. Public forums. Not concerned about the content of the flags. Are you seeing some problems? Do you understand why Boston lost this 9-0? Do you get it? They're fucking morons. They're so stupid. They're idiots. The application form asks only for contact information and a brief description of the event with proposed dates and times. The city employee who handled applications testified they had previously never requested to review a flag or requested changes of a flag in connection with approval. We never even looked at the other flags. This is how much control we had over the speech. This is how much control we had. We never even bothered to look at the other flags. That shows how much control we had. Boy, oh boy, did we sure care about the contents of those flags from the not looking at them. This is just how to lose your Supreme Court. This is just how to lose your Supreme Court case in 10 easy steps. That's what this is. This is a pile of stupid. This is just how to lose your Supreme Court case in 10 easy steps. Just say public forum, accommodate all. We don't look at the flags. We don't care about the content. We only wish you'd called it something else. Concede the point at oral argument. The city's practice was to approve flag raisings without exception. It has no record denying a request until the camps. Boston acknowledges it hadn't spent a lot of time really thinking about its flag raising practices until this case. That's because you're morons. Really? You didn't think about it. You didn't think about it at all. You're idiots. You're just morons. You didn't think about it till this moment. Hey, you know what? We have 3 flagpoles. And on one, we'll have the American flag. That sounds good. On the other, we'll have the state flag. That also sounds good. And on the third one, we'll just raise whose ever flag. Whoever asks. Whenever they ask, we won't bother to look at it. We don't care about the content. We'll just raise it. No questions asked. Here's a hand crank. We're not concerned about the implications of this. We're not worried about who might want to fly what flag on this flagpole. What could possibly go wrong? True to its word, the city had nothing. No written policies or clear internal guidance about what flags could fly and what those flags would communicate. The pile of stupid is very, very real here at Boston. The pile of stupid is unbelievably real. Compared the extent of Boston's control over flag raisings with the degree of governmental involvement in our most relevant precedents. In a different case, we emphasized Grove City always selected which monuments it would place in its park. It reviewed the monuments and typically took ownership over them. In a different case, a state board maintained direct control over the license plates. Hey, you want to submit a license plate for the back of your car? You know what we're going to do? We're going to, look at them. The facts of this case are much closer to TAM. There we held the trademarks were not governmental speech because the Patent and Trademark Office represented all marks and did not normally consider their viewpoint except on offensive occasions. And then we get into what's offensive. It has no definition. It's arbitrary, capricious. Go away. Boston, come one, come all attitude, except it is for the Camp Constitution flag is similar. A little bit. A little bit similar. The pile of stupid is so very, very real. Boston could have easily done more. This is the part where we bail out Boston, by the way. This is the part where we bail out Boston in the future. And also call them fucking idiots for not doing any of these things in the first place. Hey, Boston, since you're a bunch of morons and apparently eat crowns for fun, we will just tell you some of the things you could have done. Now, you probably should have known this in advance if you, had thought about it for 0.2 of a second. But since you didn't, let's spell it out for you in really easy to understand words. Boston could have easily done more to make it clear it wished to speak for itself by raising the flags. Other cities' flag flying policies support our conclusion. Just go copy one of theirs. Any one of them will be fine. The city of San Jose, for example, provides in writing, flagpoles are not intended to serve as a forum for free expression by the public. Well, that's a good way not to make it a public forum. Instead of anyone who wants to raise a flag is fine by us. All told, while the historical practice of flag flying at governmental buildings favors Boston, in general, sure, but the city's lack of meaningful involvement in selection of flags or crafting those messages, yet not so much. And then they note, of course, nothing prevents Boston from changing its policies going forward, which I'm sure they'll do. This is mostly just, you're a bunch of idiots. You are so stupid. Also, First Circuit, you're stupid, and District Court, you're stupid. Everyone is stupid. You're all stupid. Last, we consider where Boston's refusal to allow the Camp Constitution to raise their flag amounted to impermissible viewpoint discrimination. Well, I don't know. Boston acknowledges it denied the request because it believed flying a religious flag at City Hall could violate the Establishment Clause. And it admits this concern proceeded from the premise that raising the flag would express governmental speech. But we've rejected that premise in preceding pages. We must therefore consider governmental actions in light of our holding. When the government does not speak for itself, it may not exclude speech based on religious viewpoint. Doing so would constitute impermissible viewpoint discrimination. Applying the rule we've held, for example, a public university may not bar student activity funds from reimbursing only religious groups. Great decision, by the way, from the U.S. Supreme Court. It's a really good one to reach, that Rodenberger decision. It's a really good, interesting case. It deals with a religious media group at a college. I think it was a newspaper, but don't hold me to that. And the college, like many colleges, funds student organizations, and they usually fund media organizations. And there was a religious, I believe Christian, if memory serves, one, and they denied funding to them. And no, just again with the Smith, right? It's just again, no, you can't do that. You have to treat them the same. So even though it's a public university, if you make it available to the non-religious ones, you gotta make it available to the religious ones too. That's equal protection. Here Boston concedes it denies the request solely because the flag he asked promoted a specific religion. Under our precedent and view of government speech, that refusal based religious viewpoint and violates the free speech clause. Yeah. For the foregoing reasons, we conclude that Boston's flag-raising program does not express governmental speech. As a result, the city's refusal to let the flag fly based on religious viewpoint violated the free speech clause. We reverse the judgment and remand for case for further proceedings. I feel like this is just another case in a line of cases that is just telling them, hey, dipshits, you know, you can't actually treat religion worse. There are so many cases on point. There are so very, very many cases. And here's another one, just in case you didn't get the memo the first, dozen times. Here's another one. So, yeah. So the city of Boston, I'm sure, will change its regulations. We'll take away the public forum, because it's not a traditional public forum, mind you. It's one the city designated, so presumably they should be able to undesignate it. And, say, well, we're only flying flags under these sets of conditions, and their governmental speech is not a public forum anymore. So, yeah, that's a problem. That is a problem. Now, there was another case Stephanie brought to my attention, which we're going to speed skim because it's 56 pages long. And I haven't read it, and I don't want to read it all. But this is dealing with a habeas. So depending on this is dealing with a habeas and a death penalty case coming out of Texas. And so this is a guy who, not to be executed very much. And there's apparently some good arguments in here, Stephanie thought. And so I thought maybe we could also speed skim this decision, see what it has to say, at least in part, and, go from there. So let's speed skim this is not a case. This is a request. So this is from one of the parties. This isn't a court decision. This is one of the parties, but apparently it's pretty good. So we'll read this and see what it has to say. Well, speed skim it and see what it has to say as I speed skim rapidly. All right, so let's see. Skip. That's a lot of table of contents, man. That is a long table of contents. That's a lot of stuff we're citing. All right, let's see what we got. Melissa Elizabeth Lucio files this application for a writ of habeas corpus, seeking relief based on newly discovered evidence showing her to be innocent of the death penalty. In fact, the new evidence shows that Miss Lucio was convicted of a crime that never occurred. Okay. All right. 15 years ago, Miss Lucia's 2-year-old daughter, Maria, died 2 days after an accidental fall down the stairs. That Miss Lucia now finds herself convicted of murder and scheduled to be executed on April the 27th is a consequence of what the Fifth Circuit judge described as a systematic failure producing a train of injustice, a prosecution shadowed by federal conviction of the prosecuting DA. Wow. Now serving a 13-year federal sentence for selling his office. Wow. Okay. Miss Lucia's application details the train of injustice and new evidence establishing innocence. The conviction and sentence are accumulation of hard combinations of missteps in prosecution untethered from the truth and based on false science. Okay, skip. Okay, about 2 hours after she died, police began a coercive guilt presumptive interview. Well, probably. Gripped by shock and relief, Miss Lucia was interrogated for more than 5 hours. What did we say? What do we say, guys, about talking to the police? This is a problem. This is a problem. Please don't talk to the police. I beg you. I beg you. Of course she's a suspect. Of course she's a suspect. It's usually the husband, the wife, the mother, the father, the boyfriend. It's usually someone very, very close. So, little child dies. The mother, would be a bit of a suspect, one would imagine. So, of course. So how about, don't talk to the police. What do we say? What do we say? I want to remain silent. I want to speak to a lawyer. So many problems would be solved. But no, not so much with that. They shouted at her, berated her, repeatedly showed her photos of her dead child, and implied if she wasn't at his fault, one of her other children, her husband, would be. She asserted her innocence more than 100 times, but they refused to accept any response that was not an admission of guilt. This is very typical. This is very typical for interrogations. Suggesting their interrogation would not stop until they told them what they wanted to hear. Yeah. Or, what you could do to make it stop, it's really easy. What you can do to make the interrogation stop, it's really, really easy. You have the right to invoke Miranda at any time. It's part of the Miranda warning. They will tell you this. You have the right to invoke these rights at any time. Anytime. So even 5 hours into it, you can say, what are the words? I want to remain silent. I want to speak to a lawyer. The interrogation will end right fast. But until you say the words, probably going to keep going. After hours of this, she acquiesced, vaguely agreeing she was responsible by regurgitating words and facts the interrogators had fed to her. Yeah. With the coerced admission in hand. Now, is this legally coerced? Is it legal? It's not coerced in a legal sense. It might not be intelligent in so much as, it's not coming from her mind, so it might not be intelligent. But is it voluntary? Sounds like it. Coercion goes to voluntariness, right? For a confession to be invalid, the reason I'm making these distinctions, in case you care, and the reasons I make these distinctions, in case you care, is that in order for an admission, an interrogation to be valid, it has to be knowing, intelligent, and voluntary. Those are 3 things. Knowing, intelligent, and voluntary. Right? And the Supreme Court has ruled that without police misconduct, it cannot be involuntary. Just dead stop. End of analysis. Without police misconduct, it is never, ever involuntary. So this seems like lawful tactics. I mean, on the surface, at least the way they're describing it. So that's the reason I make the distinction, right? These seem like lawful tactics. They don't seem like the police did something that would be illegal. So therefore, what must be true? What must be true? It must be true that it's voluntary. So that's why I make the distinction. I'm like, okay, so therefore it's voluntary. So maybe we can find a problem somewhere else, like knowing. Did she know what she was doing? Yeah, I mean, she was competent. So the only thing left is intelligent. That's the only thing left to possibly find a basis, right? To suppress. So, yeah. This is the problem when you talk to the police, guys. Then someone like me, this is the problem when you talk to the police. Then someone like me, Judge Uncivil, in reviewing your motion to suppress, has to explain to you how, unfortunately, I have to let the confession in because you chose to talk to the police. I can't help you. Yeah. With the admission in stand, they continue to run the theory the murder had occurred, no matter that they were being interrogated. Her older daughters were in the same police station, giving officers statements that they corroborated Lucia's account of the fall down the stairs and denied abuse. Words from your own mouth, man. The jury eats that shit up. These statements were suppressed, only coming to light after the initial habeas. So perhaps these statements were not given to, I mean, that's what I assume they mean by suppressed by the police. But I don't know that you necessarily have to disclose that, to be quite honest. And I mean, it's not exonerating evidence. I mean, and to the extent it is, it's like your own children. You kind of know about that, so I don't know. The state's medical examiner was influenced by the state's hypothesis and failed to investigate causes. Contributions to death had nothing to do with intentional force. Again, this is the attorney writing, so I wouldn't take that as necessarily true. Failed to consider medical history, which includes trouble walking and documented falls, as well as traumatic brain injury. I'm not going to take that as a given either. Without forensic or eyewitness to support the case for capital murder, the state's case was built upon the lengthy interrogation. I mean, yeah. Unscientific and improper analysis of her affect and demeanor following her daughter's death. Yeah, that's no go. That's just body language bullshit. Right? That's some bullshit. Right? Her demeanor following her death. Well, at least if it's not an expert, I guess. If it's not an expert opinion, if just people were describing how she acted. But they said specifically an unscientific analysis, which to me suggests it's not lay people's opinion. That's suggesting like an expert psychologist's opinion, which is bullshit. And testimony from the state's pathologist claiming, contrary to evidence, that death had to result from abuse. I mean, I'm not going to take that as given either. But for the use of the false testimony, no juror would have voted convict. Quite possibly true. Jurors eat that shit up. Jurors, it is their favorite thing in the world. It is absolutely their favorite thing in the world. It is better than video evidence. It's better than an audio recording. It's better than DNA. It's better than forensics. It's better than blood on the clothing, tire tracks, footprints. What is the jury's favorite thing in the world? The confession from your own mouth. The confession from your own mouth. And good effing luck undoing that bell. It's their favorite thing in the world. Don't talk to the police. All you have to do is say, I want to remain silent. I want a lawyer. Just say that. Repeat as required. So Dr. Farley's testimony was false, contradicted by science and every contemporaneous eyewitness account. Well, to the extent it's contradicted by every contemporaneous eyewitness account, the question is, did those eyewitnesses testify? Because if the eyewitnesses testified, then it's just a question of fact for the jury. It's a question of fact for the jury, you know? I've got 10 eyewitnesses who were with me at the time who say I didn't do it. What do you have on the other side? The medical examiner and my confession? Okay, jury, which do you believe? Do you believe the 10 eyewitnesses, or do you believe the medical examiner and the confession? You don't really want to be in that position now, do you? You don't really want to be in that position. Okay, jury, you have to be convinced beyond a reasonable doubt. Which do you believe? These 10 people, or the medical examiner and the confession? It's up to you. You're the judge of the facts. Which do you believe? Beyond a reasonable doubt. Don't put yourself in that position, please. Previously unavailable scientific evidence entitles her to relief. So this is going to be like her only hope, really, in the habeas, I think, is new evidence. New evidence that basically proves innocence is really her only hope. Because, like, all these other issues would have been decided on appeal. And we're in a collateral proceeding on a habeas. So, like, I think her only hope is to show prosecutorial malfeasance, which we've alluded to it, but we have to show it specifically in her case, you know, or some new evidence that would basically prove her to be innocent. So, you know, kind of difficult. All right, since the trial, scientific evidence has illustrated that bite mark evidence is invalid. Okay. The conclusions regarding cause of death are undermined by forensic confirmation bias. Could have been attacked during the trial, right? The bite mark analysis, I'm going to assume they didn't know. Couldn't have been attacked. Okay. The bias, that could have been attacked at trial. I don't think that's a basis. Uniquely susceptible to false confession due to her lifelong history of trauma. Again, something that's not new evidence. The state witness purported ability to read the demeanor was scientifically invalid. Was that known at the time? I would think, was it raised at the trial court? Like, so many of these things seem like trial court issues. Like, the only thing that's really new, apparently, is the bite mark evidence, because that's been shown to be scientific crap, right? So we're going to take away that piece of evidence. And then what we do is an appellate court, well, assuming we're on appeal, which we're not, we're on a collateral. But if we're on appeal, we're like, okay, let's take away that piece of evidence. Could the jury still convict her anyway? Without the bite mark evidence? Well, she confessed. So, you know, yeah. How do you overcome that? How do you overcome that? You would have to show that. You would have to show that so much evidence piles up against the confession, right? The overwhelming weight of the evidence in total goes up against the confession. And good luck, right? Don't talk to the police. You won't have these problems. Just invoke your rights. It's really easy. The police will read them to you or give you the card, and probably both. They will tell you. They will tell you you have the right to remain silent. All you have to do is say, I want to remain silent. I want an attorney. That's all you have to do. And you won't have to be on death row for killing your child when the murder maybe never happened at all. Don't talk to the police. She's entitled to a new trial. I don't know, man. The additional errors are myriad and affect both the liability and penalty phase. Trial counsel provide constitutionally ineffective assistance. Did we raise that issue at appeal? If not, why not? If we did, then how can we double check I confess to the police I did their mom? Don't do that either. Don't be cute. Seriously, don't do it. Don't be cute. Don't go down that road. But did we raise the ineffective assistance of counsel on appeal? If not, why not? And if we did, how did the appellate court get it wrong? The state violated her right to due process when it suppressed evidence favorable to her defense. It shows that from the beginning, police and prosecutors were aware of the witnesses confirmed the account and death. Eyewitnesses had said they'd not abused Mariah or any of her children. But those eyewitnesses were known because she would have known about them. So I'm not sure. And also, to the extent there's a Brady violation, did we not raise that issue? Apparently we didn't. Apparently we didn't know that until the first habeas. So we're going to try to undo this. We're going to try to undo all this on a potential Brady violation for failure to disclose these witnesses. I mean, maybe, but you know, it's not the position you want to be in. The state violated the Sixth Amendment to be free from unconscionable pre-trial investigation, where nearly a year after she was arrested, the state used a therapist to meet with and elicit information. Bullshit. Bullshit. Did they give you Miranda? Then they didn't violate the Sixth Amendment. Portions of the therapist report were misleadingly used during cross-examination, but the reports themselves were not provided to the defense. Well, that sounds like a problem. Was that issue raised to the appellate court? Because you would know whether or not you had the reports at trial. I mean, obviously, that's not a new issue. How could it possibly be a new issue? Were you given you would know whether or not you had them. Did you raise the fact that you didn't have them at trial? Did you preserve that issue? Did you bring it to the appellate court issue? Why are we relitigating this now? Yeah. Yeah. Did I get breaking news? Is there breaking news? What breaking news is that? I see in chat there's some sort of breaking news. What is that? Looks like Roe versus Wade is getting overturned with a leaked draft opinion. Oof. First of all, the idea that the Supreme Court doesn't leak. Kurt is on an assumption train. Okay, David, I'm not on an assumption train. Not really. I mean, first of all, I'm asking questions. So I'm not assuming very much. I'm like, did you raise these issues? If not, why not? And if you did, why did they? I'm asking questions. So first of all, I'm not raising assumptions. Like, because I'm asking questions. Did they know about this? Did they raise this? If not, why not? If they did, why the appellate court? I'm asking questions. Second of all, to the extent I am making assumptions, I can make a lot of assumptions because she was convicted. So, you know, there's that. The Supreme Court has voted to strike down Roe according to initial draft opinion obtained by Politico. I don't know how they got it. The Supreme Court just doesn't leak like ever. I'm just skeptical because the Supreme Court doesn't leak. But you know, it could be true. They overturned Roe. Yeah. Also, for whatever it's worth, even a leaked opinion isn't a final opinion until it's issued. So even assuming it's authentic, it doesn't mean that it's the court's opinion. Because up until the moment it's issued, it can change. So it would literally be a draft, which might reflect a whole bunch of things. It might reflect one person's view. It might reflect some people's views. It might have reflected some people's views at one time and not now. So I don't, wouldn't necessarily put a lot of, draft doesn't mean anything. Votes can change. Votes can literally change up until the moment it's issued. So I don't know how much faith I'd put in that by Politico. But I'm curious. Let me take a quick look at what Politico is saying about this, just real fast, because I'm interested. I mean, Politico is a fairly reputable resource. So I mean, there's that. Let's see what they're saying. We hold that Roe and Casey must be overruled by Justice Alito. Initial draft. They have a draft. You guys want to take a look at the draft? You guys want to take a look at a draft and abandon this thing? I want to take a look at the draft. I want to take a look at the draft. Now, all right, what we need to do, this is huge news. I don't want to attach it to this stream because I don't want to bury it in the stream. I need to create a new stream with a new title, and I need to do it like right now. Yeah. So I'm going to end this stream. And I'm going to start a new stream with a new title, and we'll go from there, and we'll read the draft, and I'll do all the caveats at the beginning of that so people don't lose it. All right. So I'm going to end the stream. I'll probably wait a half hour. I'll announce it right away. I'll probably wait a half hour so people get news, and we'll do it again in a half hour. So like 8:35 my time, and we'll do it from there. Okay. So look out for the new stream. It'll be coming your way in just a minute. I've been on Civil Law till half hour from now. Cheers and goodbye.